My name is Bradley William Brunon, Brunon.
Mr. Brunon, what do you do for a living, please?
I'm an attorney.
And in 1989, was Dr. Jerome Oziel a client of yours?
He was.
Either on Halloween of 1989 or within a day or so of that date, did Dr. Oziel call you with a matter of concern to him?
Object to that question is leading us to time.
Overruled.
Yes, he did.
Now, do you have a specific recollection sitting here today of what the date was that Dr. Oziel called you?
Not exactly, no.
Do you remember that it was near or on Halloween, or do you have any recollection as to that?
My recollection has been refreshed within the last week as to that time period. Whether or not it was Halloween or the next day, I can't tell you, but it was in that period.
Could you see if you can move the microphone up, please? I think, no, all right.
Higher?
All right, Mr. Brunon, when Dr. Oziel called you, were you at your home or your office, if you recall?
I was at home.
And would you describe his demeanor? That is, how did he sound to you on the phone?
Okay, I didn't see him, but he sounded excited, anxious. He was speaking more rapidly than he normally did, or than I had normally been accustomed to hearing him. And he seemed to have some tension in his voice.
Now, at that time, in either October or early November of 1989, approximately how many years had you known Dr. Oziel?
In 1989, I had known him probably 4 or 5 years.
What did he say to you when he called you that day, or that evening, pardon me?
I don't remember exactly how he began the conversation, and I don't remember the conversation sequence by sequence, sentence by sentence, but he informed me that he had clients who had admitted to him that they had committed a serious offense. And after they had told him of the offense, they had said to him or made statements to him that he took to be threatening. And he wanted to know what he could do under the circumstances. What were his options? What did I think about that?
What did you tell him?
Well, I asked for more information, and the conversation was not as sequential as this, but I asked him a little bit, how serious was the offense? And he said, well, it's the most serious. It's murder. All right. What does he know about it? And he said, well, there's not much evidence. His understanding was that the facts had not been developed.
Object to the statement about his understanding being a conclusion.
Are you relating what was told to you by Mr. Oziel?
I am, Your Honor.
All right, objection overruled.
And I asked him how serious he felt the threats were, and he said he felt that they were serious. So, well, here are the options as I see them at this point. You can call the police, and the police will either act at this point or not act. Depends on the balance of the facts. And since I don't know the facts, I can't tell you whether or not they would act. If they do act, then his patients would be arrested. And so at that point, they would present less of a threat to him. If the police, for whatever reason, elected not to act at that time, the investigation hadn't developed far enough, or it was still under active investigation. There's all variety of reasons why they might not act even with a confession. Then if that information came to light, he would be in peril. And I discussed with him the impracticality of having a full-time bodyguard for himself and his family. He has a wife and 2 children, and it's just impossible to have full-time armed protection.
Let me interrupt you and ask another question, Mr. Brunon. Aside from the option of calling the police or hiring a bodyguard, did you discuss any other options with him?
Well, the conversation evolved. I explained the balance of the system, how it would work, that even if the police acted, you couldn't accurately predict what the prosecution would do at that point. Because once an arrest has made, certain time limits start applying, and they may not elect to file at that point, and so he would be in danger.
Now, by file, could you just explain what you mean about filing?
After an arrest is made, essentially in most instances, on the belief by the officer that a crime has been committed. reasonable suspicion, reasonable belief. The prosecution then reviews the facts that the police present to them and make an election to file the case because the facts present potential of a criminal prosecution. And in Los Angeles County, my understanding of the filing criteria is that the district attorney wants to have sufficient facts at the time of filing from which they can prove the case beyond a reasonable doubt. They don't use a reasonable suspicion filing standard. They use
I
a...
object to that, Your Honor, to strike, it's his conclusion, he doesn't look to this.
Well, the objection is sustained as far as the conclusion of the witness. At this point, we want to confine ourselves to what it was he told Dr. Oziel.
I'll continue then. Mr. Brunon, do you have a specialty as a lawyer?
I do.
And what is your specialty?
I'm a certified specialist in criminal law, and I have practiced only criminal and administrative law for 23 years.
Mr. Brunon, did you explain to Dr. Oziel the procedures by which a case may or may not find its way into the system?
I did. And
And what else did you advise him?
that was basically it in terms of the system, that I just couldn't tell him with any degree of certainty what would happen if he revealed the communications to the police or other prosecutorial authority. And we discussed briefly witness protection, and that also was impractical because of his profession, his property ownership, the circle of friends that he has, and business acquaintances. Witness protection was out of the question. And so we eventually, the discussion evolved to the point that he would maintain contact with his patients and monitor the relationship so that if he felt that the peril was too great, that there was something imminent that was to occur, then he would consider changing his tactic. But in the meantime, he would try to maintain continuous evaluation of the situation.
And when you say, I think you said something like monitor his patients, are you saying the people that he had referred to as having made these statements to him earlier and threatened him?
Yes.
Now, on March the 8th of 1990, several months after you had this phone call with Dr. Oziel, were you called to his home in, I think it's Sherman Oaks?
Yes, I was.
And when you got there, was Detective Zoller there along with some other personnel from the Beverly Hills Police Department and other agencies?
Yes. All right, we'll resume.
Mr. Brunon, on March the 8th of 1980, did you get called to Dr. Oziel's home in Sherman Oaks?
Did you say 1980?
I'm sorry, I meant to say 1990.
Yes.
And at that time, were the police there executing the search warrant?
Yes.
Were items seized pursuant to that search warrant?
I know there were, but I didn't. Well, yes, I saw some items there as well.
All right. Now, in the summer of 1990, did Dr. Oziel assert the privilege as to matters that were taken, as to items that were taken from his home during the execution of the search warrant in March?
Yes, he did.
And did he hire you to represent him in that proceeding?
I was already representing him, but I continued to represent him in that regard as well.
On or about December the 7th of 1992, did Dr. Oziel testify in front of the grand jury?
He did.
And was a court order required by you for him before he testified? Let me rephrase it. Did you ask the prosecution to get a judge to sign a court order ordering him to testify?
Well, I told you, I believe it was you, that Dr. Oziel would not testify except upon court order.
And was that provided to you?
It was.
Thank you. I have nothing further.
All right, cross-examination.
Mr. Brunon, as a certified criminal law specialist, are you familiar with Evidence Code Section 1015?
I don't have them memorized. I'm sure I know the content,
Could I show it to you to refresh your memory?
if you like.
Here, I have this one.
All right. And do we have the same ones? Oh, yes, 1015.
Could you tell the jury what what that says.
That's a section in a group of sections dealing with privileges, and that requires a psychotherapist, someone who is a privilege holder, such as a psychotherapist, such as a psychologist, as Dr. Oziel is, to claim the privilege in the event some third party wants to know about a confidential communication.
For instance, if a court or district attorney asks Dr. Oziel to come to court and testify, he's legally obligated to claim the privilege under that section, right?
If he's asked to testify about a communication from a patient that is not accepted, yes.
Okay. And I think you said you had known Dr. Oziel 4 or 5 years before 1989. Is that correct?
Approximately.
Could you tell us how you came to know him?
Sustained.
Could I approach on that, Your Honor?
Yes.
Thank you. Mr. Brunon, is it true that you first were introduced to Dr. Oziel in regard to a situation before the licensing board involving an individual named Court Day?
I'm not sure that that's when I first met him, no.
Is it true that you represented him in settlement negotiations that related to the Court Day litigation?
That is true.
And you, in fact, negotiated a settlement in that case?
I did.
And did you continue to represent him on other matters after the Court Day litigation?
I don't know if I recall anything else coming up, but I continued a relationship with him thereafter.
Was that a professional relationship or also a social one?
Not so, we're friends. I mean, we're friendly. I like him. And so we have that relationship. He calls me from time to time if an issue comes up. But, well, does that answer your question?
Well, did you represent him on other litigation or licensing board matters other than Court Day in the period before 1989 when he made this telephone call to you?
Sustained.
Did you represent him on any matter in late October, November 1989 when he called you?
I don't believe no, not at that
In
time.
other words, you had nothing outstanding with him at that point.
No,
And is it true that you have represented Dr. Oziel in this case? That is, as a witness, you've appeared in this court and represented his interests before this court. Isn't that true?
yes, I have attempted to.
And you've also represented his interests in other courts relating to this case, correct?
I have.
You filed litigation for him involving service of the search warrant, for instance.
We tendered that so that you all could resolve it. We did tender that, yes. We didn't litigate it, but we tendered it.
Well, you filed a separate lawsuit about protecting a videotape of the search warrant services.
Well, that was for his own private interest.
Right.
The news.
I don't want to go into the
All right.
details. I just.
But
am
yes, I
interested
did.
And you have appeared in this court, in Judge Weisberg's court, on several occasions and argued on behalf of Dr. Oziel, have you not?
I think 2 occasions.
And there are also other lawyers currently representing Dr. Oziel, correct, in civil matters.
Sustained.
Do you know if there are other lawyers in the courthouse right now who represent Dr. Oziel or who were here earlier today?
Sustained.
Now, Mr. Brunon, have you told us to the best of your recollection everything that you remember about this conversation you had with Dr. Oziel?
No.
Is there anything else that you can remember about the conversation?
Yes.
Could you tell us what else he said to you when you had this conversation
All right.
that you consider not privileged? Not asking for privileged information.
I understand, and I'm considering the entire conversation to be unprivileged. The one thing that wasn't asked, or the one additional thing that may be material, is that during the course of the conversation, he brought up the idea of preparing a tape recording or some sort of a communication that he would place in the hands of a third party and advise the patients of its existence and its content, which would be a summary of the statements that had been made to him, the confession. And he asked me what I thought about that, and I thought that had some efficacy and perhaps protecting him from some untoward events.
Now, you said your memory was refreshed as to the time of this conversation by something you saw or looked at last week, was it?
Either the end of last week, the weekend, Monday or Tuesday, sometime after Dr. Oziel began his testimony.
And what was it that you saw that refreshed your memory as to the date of this conversation?
It's not the date so much as the time frame. And I have 3 sources of data on that. I talked.
I'm going to object to that the answer's not responsive.
Well, the question has to do with what refreshed his recollection. Is that what you're asking?
Yes.
Are you answering that?
I'm trying to. I don't know mechanically what caused the synapse in my brain to cause me to remember it, but I talked to Dr. Oziel after he had testified about it to learn the parameters of his testimony because of the attorney-client privilege. I needed to know what the scope of his testimony was so I could guide my testimony. That helped me recall when it occurred.
All right, let me stop you right there. When you say the parameters, do you mean Dr. Oziel told you the dates? Are we talking time parameters?
I don't. Well, also the scope of the testimony, how much he testified about that conversation. I don't know. I wanted to know if he just said he had a conversation or if he went into the contents of it with me so that I would know whether or not I could go into the contents of it. And I don't recall if he mentioned the date, if I saw it in the newspaper, or if I saw it on one of the newscasts of it. But wherever I saw it or heard it, it struck a bell with me. Yes, that's when it did occur.
All right. So let me ask, is there anything else you used to refresh your memory other than what you just referred to?
No,
Now, is it true that you didn't take any notes of this conversation?
that is true.
Did you bill him for that particular session? And
No,
I don't mean that offensively. I'm trying to establish the
No,
dates here.
no, I didn't bill him for that.
And do you know what your office telephone number was on the date that you received that call?
I do, but he called me at home.
And what, if you don't mind telling us, would you mind telling us what your telephone number was?
Well, I don't know if, assuming it's the same phone number.
Yeah, it is, but I don't think it would help you because it was in Santa Monica and it's a local call.
And he was in, at that time, Beverly Hills.
That's my understanding.
And do you remember the time that the call came in?
It was in the evening. My best guess would be 9 or 10 o'clock. It was not 7, 8 o'clock. It was later than that, 9 or 10 o'clock, maybe even a little bit later.
And from the time you received that call up until today, how many conversations have you had with Dr. Oziel concerning the events that you testified about here today, would you say?
Could we be more specific as to which events you're talking about? You're talking
I'm
about
talking about the telephone conversation that you testified about here today.
The conversation continued. There was a first conversation, and then we had subsequent conversations immediately thereafter in the next week, 10 days, just to see how it was developing. Then we didn't talk about it until this past week.
All right. And when you were representing him, you represented him in the Santa Monica Superior Court during proceedings there, correct?
Yeah, yes, I did.
You actually appeared in the Superior Court and was there as Dr. Oziel was testifying, isn't that true?
I don't think I attended his testimony. I think an associate from my office did.
Did you ever discuss with him during that time period, that is a period of time when the litigation was going on in Santa Monica, the events that you've testified about here today concerning the conversation?
Not to my recollection. I don't believe I did.
And could you tell me how seeing the date or having this conversation with Dr. Oziel pinned in your mind when the conversation took place that you testified about?
I didn't hear the first part of your question.
Could you explain to me how seeing something in the newspaper or talking to Dr. Oziel allowed you to bring back in your mind within a 2-day period when this conversation took place?
Well, I was familiar in general terms with the sequence of events, the homicide in August, the search warrant in March. So that gave me the outside parameters. And I don't know the mental process of how it did it. All I know is that after I heard that, it sounded right. I mean, I could be wrong, but I think I'm right. I don't have an independent recollection of looking at the calendar, for example.
In other words, did the information sound right, or did the date sound right, or did they both sound right?
Both.
Now, is there anything, can you say it was on October 31st?
Not with absolute certainty, no.
Can you say it was on November 1st?
I can't say what day it was with absolute certainty. I can say it was in that time with a high degree of certainty.
And can it be as late as a week after November 1st?
I don't think it was that late
And can you tell us why you can eliminate that with a high degree of certainty?
because of the planning and preparation. Well, there were certain things that he said he was going to do, which was, the main thing was the preparation of the tape and the evolution of that. And I know approximately when the tapes were created, so it was before the creation of the tapes.
How do you know when the tapes were
No, I'm
created?
going to object at this point. Mr. Parrish.
Could I rephrase the
Yes.
question?
Can I confer with counsel?
Sure. Mr. Brunon, do you know, based on your recollection of that conversation, whether Dr. Oziel had talked to anyone else? Did he say that you were the first person he was contacting regarding this?
Objection, are we talking about the conversation on or about the October 31st?
Well, whatever date it was, the first time he called you about this.
He said he had talked to someone else.
Did he say who that was?
I don't now recall if he did or didn't.
And did he say that the patient or patients had confessed to him?
He did.
Did he present it to you as a hypothetical case, or did he name names?
He did. I knew who he was talking about. I don't think he named names
How did you know who he was talking about?
because I had read the paper. I was familiar with the facts of the case. I knew that Lyle and Eric were his patients.
And so did he begin by saying the patients and then you said, I know who you're talking about? Is it-
I don't think he ever said the names. I don't know if I said the names. I believe I said, I think I know who you're talking about.
Right. And at some point during the conversation that it was not just a hypothetical situation, the two of you were discussing this case, correct?
Well, we were discussing what became this case, and no, I didn't treat it as hypothetical.
And did he tell you the details of the confession?
No.
Did he say to you that he was threatened?
Yes.
Did he say to you that anybody else was threatened?
No.
And I think you said that at the end of the conversation, correct me if I'm wrong, that a resolution of some kind was reached that he would continue in the relationship with the patient and monitor, I think is the word you used. Do you recall that?
I did use that word, and resolution probably is too concrete of a word, of a term, or may imply that we had figured out exactly what he was going to do, and that wasn't the case. I left it. I said, I can tell you legally what may or may not happen, based on what you're telling me and my familiarity with the legal system. I can tell you, we'd already acknowledged that he could report it because of the threat that had been communicated. I didn't know his relationship to the patients, and I said, you're just going to have to make the call yourself, because I can't predict that. I don't know the people you're talking about. I don't know them as well as you do, so I can't evaluate it. So you're just going to have to make that decision as to what you actually do.
And do you remember what you said about calling the police?
I said that was one of the things he could do.
And did you tell him that the police or the prosecution, once in possession of the confession, that there would not be a conviction? That
No.
There was no chance there would be a conviction if he handed over a confession?
No, I said I told him I didn't know what the outcome would be because I didn't know the balance of the case. And it has been my experience that a confession is, highly material evidence, but it is not always determinative.
Right.
And I tried to convey that to him.
But did you ever say to him that based upon your experience as a criminal law attorney, that based upon the evidence that he said was existent, that it was at best the flip of a coin whether there would ever be a conviction? Did you ever make that statement to him?
I don't know. I attempted to convey to him that it was impossible to predict what would happen with any precision, that they may or may not arrest, they may or may not indict or file a complaint. And after that, what happens in the system is anybody's guess.
And you have no specific recollection of telling him that if there was a confession, it would be a flip of a coin as to whether anybody would be convicted.
I don't recall using those words. I could have said something in that sense.
And was that based on your knowledge that the validity of, that the reliability of a confession turned somewhat on the source of who was saying the person confessed?
Judge calls for an opinion for which he's not being offered some expert.
Objection sustained.
Did you tell Dr. Oziel that based on your experience, confessions, especially from unreliable sources, were sometimes not trustworthy and not good evidence? Words to that effect.
No, I wouldn't have said anything like that.
You said in your direct examination that Dr. Oziel said to you that there was not much evidence. Do you recall that testimony?
That he told me that was his understanding.
And did he indicate what evidence there was, if you remember? If you don't.
You're talking about other than the confession?
Yeah.
No, he didn't. I mean, I don't recall him doing that.
He may have, you just don't recall.
I don't think he did. Nothing rings a bell as to what he may have said. And my understanding independently of that at that time was that there was not a whole lot of
Well, I'm not
evidence.
asking for your understanding. I'm asking what you told, what
All
he
right.
told you.
I don't recall him elaborating on what evidence, if any, existed at that time.
Thank you.
All right, cross-examination on behalf of Eric Menendez.
Thank you, Your Honor. Mr. Brunon, you made a certain assumption here that Dr. Oziel, on whatever night this was, called you from his office, correct?
I assumed that he called me from Beverly Hills.
Well, that's what I just said. You assumed that, correct?
You said office. I said Beverly Hills.
All right. Well, did he live in Beverly Hills?
He lived over the hill from Beverly Hills.
Okay. Did you think he was calling you from his office?
I didn't form an opinion at that time as to where he was calling me from.
All right. Then let's assume, just for the sake of this question, that you don't know where he was calling from, correct?
Okay.
All right. And therefore, where you lived, Santa Monica, could well have been a toll call from wherever he was calling from.
It could have been.
And because this is being televised, I don't want to ask you openly for your telephone number, but I would ask you to write it down on a piece of paper.
I will be happy to do that for you.
Thank you.
May I approach him?
Yes.
And may I mark this piece of paper that Mr. Brunon is going to mark? Next in order, though I don't know what that is.
136.
Thank you, Your Honor.
Your Honor, may I request that this not be released to the media?
Yes. You may request that.
Well, since I have no standing, I can't move for it, I suppose.
Okay, I will take this away. Thank you, Mr. Brunon.
You're welcome.
During the course, well, strike that. You said you had known Dr. Oziel for some time and that you were friendly with him. Did you know Judelon Smith as of Halloween of 1989?
I can say that as of this moment, I do not know Judelon Smith.
Had you ever heard her name mentioned to you by Dr. Oziel before October 31st, 1989?
Objections beyond the scope.
Sustained.
Well, Your Honor, this is just foundational.
Objection sustained.
Did he tell you during the course of this conversation that he had told all the details of the supposed confession to a Judelon Smith before he ever talked to you?
He didn't tell me that.
Did he tell you that he had told the details to a girlfriend?
No, he didn't tell me that.
Did he tell you that he had told the details to a business associate?
No, you're still talking about Miss Smith, I take it?
Let's just say he might have used those words. Did he tell you that he had told anybody?
He told me that he had discussed it with either other lawyers or other
Therapist.
therapists, I don't know, psychiatrists or psychologists, but other people trained in that area. And
Did he ask your advice on whether he should tell a woman that he was having an affair with about this supposed confession in order to protect her?
he did not ask me that, no.
Thank you, Mr. Bruno.
You're welcome.
All right, any redirect?
No, thank you, Your Honor.
All right, thank you. You may step down. You're excused.
Thank you.
All right, in discussing the scheduling with council, there are some matters that the lawyers and I will be discussing a little bit more this afternoon and then tomorrow morning. So we're optimistically expecting to be ready with more evidence at 10:30 tomorrow morning. So we ask that you, both juries return at that time to your respective jury rooms. Don't discuss this matter with anyone or form any final opinions about it. And we'll see you back here tomorrow at 10:30. Hopefully by then we'll have finished our discussions and be ready to proceed with further evidence. All right, the jurors have left and counsel indicate they have some brief evidence you want to offer. Could you just give me an idea of what the issue is here?
Yes, Your Honor, the people want to admit evidence with regard to the hotel that Eric Menendez went to after the death of their parents. The inference being, which is the advantage that they should find something more modest in the
Okay.
hotel.
Yeah.
So I would like to call Henry Llanio with regard to the selection of the hotel.
Okay.
Mr.
All
Llanio?
right, step forward, please.
Raise your right hand. You do solemnly swear that the testimony you may give in the cause of pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. So sure. Please take a stand and state your name for the record.
Enrique R. Llanio. That's ENRIQUE, middle initial R, LLANIO. I'm also known as Henry.
Mr. Llanio, do you know Lyle and Eric Menendez?
Yes, I do.
Are they your nephews? Cousins?
They're
I'm
my
sorry. They're your
first cousins once removed, technically.
Okay. Did you see Lyle and Eric Menendez sometime shortly after their parents died on August 20th, 1989?
Yes, I did.
How close in time was that? When did you first see them after that date?
It must have been around 9 o'clock in the morning,
The day after?
the 21st.
Did you have any discussions with them with regard to where they would be staying
Yes, with Lyle.
with Lyle? And were you involved in the decision with regard to where they would stay?
Yes.
And what suggestions in that regard did you make?
Well, I felt that they should not be staying with the rest of the family at the Bellage Hotel for security reasons.
Okay,
And I suggested that we either go to the Beverly Hilton, I believe, it's the one that I passed by there all the time on the way to the house, or to the Bel Air Hotel, which are the two big hotels in the area that I was familiar with.
okay. And did you take Lyle with you to one of those hotels?
Yes, we went together to the Beverly Hills Hotel first. Beverly Hills, I believe, the one on Sunset, whatever the name of that is.
And was this at your suggestion that you
Right.
went to that hotel? And were you shown a room at that
Yes.
location?
Yes, I asked to see a room that before we committed to it.
Okay,
And we went upstairs to the room, and Lyle seemed to be fine with our room, but it was a room in a hallway, and it was depressing to me. I felt depressed in it, and I said, "This is not it. Let's go somewhere else."
okay. And did you take him somewhere else?
Yeah,
Where did you take
I
him?
had to get directions how to get to the Bel Air Hotel because I had never been there. I just had heard about it, and we finally found our way in that place. It's not an easy place to find.
And when you got to the Bel Air Hotel, did you again ask to see a room?
When I got to the Bel Air Hotel, I asked not only to see a room, but I asked to talk to the man in charge of security. And then I asked him to show me something that was secure and that was big enough to accommodate not just my cousins, but also that family members were flying in, and I'm sure that there were going to be, meetings there. So, and I also told him who they were, or actually I told him who Lyle was. Eric was not present. And
Were you doing all the negotiating?
yeah, I was, and I was asking, what kind of security they had there to offer, and and the man assured me that I think it was an ex-policeman himself, the man in charge of security at that time. He assured me that they would be safe there.
And did you make a decision with regard to where they would be staying then?
After they showed me the room, that yes,
And what was the decision?
yeah, I told Lyle, I think this is it. You should take this room.
And during the period of time that they stayed at that hotel, did family members in fact come there frequently?
As far as I know, yes. I dropped in from time to time, and there was always Carlos Menendez and Terry. I believe Marta was there too at one time. There were people in and out of there all the time during that brief period of time. You have to understand that this was just a few days before we all went to New Jersey
I
for
understand
the
that.
funeral.
And when other people were there, were they ordering food or using the services of the hotel? Or do you know?
I don't know. I do know, because when I walk into one of their one of their meetings, I saw food everywhere. So I would imagine that they had consumed it, or they were in the process of consuming it. I was not there long during their meetings.
Okay. Now, the people whose names you've mentioned, are those all relatives of Lyle and
Yes.
Eric? Thank you. I have nothing further.
Mr. Llanio, you were aware that the Menendez family moved from New Jersey to California at some point in about, I think 1986 or 7, is that correct?
86.
And how many times did you see the Menendez family before the parents were killed? How many times had you seen the Menendez family in California since they'd arrived here?
Okay. Well, I saw my cousin Jose when he first arrived before he bought the Calabasas house. And I believe I saw him once at the Marriott Hotel. And then I was with Kitty. I went to see Kitty and Eric at the Oakwood Garden Apartments, which is a temporary place where they stayed before they could find a residence, once to determine what type of house they were looking for, because they wanted me to show them around and find them a house.
Let me ask you a question. You were aware the family moved to Beverly Hills, is that correct?
Yes.
How many times did you go visit them in Beverly Hills before the parents died?
I believe I was there twice,
You were close.
maybe 3 times.
Now, Mr. Llanio, how was it that you came to be in charge of making these arrangements at for the stay of the brothers after the murder of their parents? Were you elected?
Self-appointed. Well, election,
I think he's answered it.
election, I just answered your question. I was self-appointed.
Okay, now,
I took over.
all right, and you decided that the hotels you wanted to look at were the Beverly Hills Hotel on Sunset Boulevard?
I believe that's what it's called now.
It's the pink one?
Yeah, whatever. I'm colorblind. Whatever.
All right, and the Hotel Bel Air, is that correct?
Yeah.
And did you pick out the room that they were to have at the Hotel Bel Air?
Well, it's hard to answer that, because what happened is that they showed me a room that I liked, and I said, this is it. So if that's picking out a room, I mean, I was not offered a whole barrage of rooms and prices and whatever. I was not concerned with money at that time, personally, and I didn't think that this was a time for anybody to be concerned about money.
Did you pay for the room?
No.
Do you know who paid for the room?
I was under the assumption that probably Life would pay for the room, because Life, I think, was paying for the suites, including the one that I was staying in at the Bellagio Hotel.
Now, do you know that the hotel bill came to approximately $8,800?
I had no idea.
Okay. So it's your testimony then that you took charge and you picked out the hotel and you
Yeah.
said, this is the room, and you weren't concerned with money, is that correct?
Correct. If I would have had to pay the $8,800 myself at that time, I would have done so.
Mr. Llanio, when you did this, I take it you were only with Lyle Menendez, is that correct?
That is correct.
And did you ask for a suite when you went to the Hotel Bel Air?
I think I already testified to that what I asked for was some place that was big and big enough to not just for the two boys. And they showed me, as a matter of fact, now you're refreshing my memory now. They did show me this room that had two rooms, two bedrooms type of thing in it. And it had like a large area, living area type of thing with a nice table and a kitchenette. And that's the only room that I saw, and I liked it.
But you were not involved in negotiations for how to pay for the room, is that correct?
Well, I don't think you don't negotiate with a Bel Air hotel. I think I asked them how much the suites were, because at some point I may like to stay in a room as nice as that. But I was not concerned with, there was no negotiations per se.
And when Menendez was with you, did he ever say to you, no, this room is too fancy or too expensive or we can't afford it, or anything to dissuade you from choosing that room or that hotel?
No.
Okay, thank you. I have nothing further.
Okay, thank you, Ms. All right, we'll be in recess until tomorrow at 9 o'clock. Got certain matters that council want to resolve prior to the testimony of the next witness. What is it the council wish to do at this time?
Your Honor, I have an agenda of the things I think we need to resolve before we try to complete our case. The first one is the issue of whether or not a representative from the Hotel Bel Air can testify. The second one is the Marina City Club. The third issue is the Calabasas burglaries. Yeah, we have to discuss the Calabasas burglaries. We want to also discuss.
Hold on a second.
I'm sorry.
All right, we have some jurors come in first.
Eric's stuff. Do you have one for Lyle also?
I'm not gonna put it in.
Okay. So this is just for the scrapbook. This is Lyle. The first one's Lyle.
I'm not gonna put it in the last one.
All right, I was at the point where you had informed me of Bel Air Hotel, Marina City Club, and the Calabasas burglaries.
And the
What was next?
Calabasas burglar issue is that we have been unable to reach a stipulation with the defense on that to avoid live testimony. The other issues are the Billionaire Boys Club movie and Mr. Heffernan. We've been unable to reach an agreement as to, we were going to try to stipulate to his testimony, but we could not reach an agreement. And then I think that's it as far as issues in dispute. And then when we finish our case, we want to talk to the court about discovery from the defense, and what the parameters are once the case starts. But that doesn't have to be done now.
And who is the next witness you propose to call?
Ms. Gilma Castro, who's the custodian of records from the Hotel Bel Air. We also have here present Valerie Hart. I believe that would be in front of the Eric Menendez jury. She's from the Marina City Club. And the Calabasas burglary issue is something that if it's not resolved today by stipulation, we're going to have to call the live witnesses in for Monday. And then Mr. Heffernan is also present. I don't know if he's in the hall or in our office, but he is present. So we have three witnesses, Mr. Heffernan, Valerie Hart from the Marina City Club, and Ms. Castro. And then Detective Zoller as well for today.
And in regards to Mr. Heffernan, what is the area of dispute that has to be resolved?
You know, there were a lot of objections made with respect to Mr. Heffernan. I agreed to put the evidence about Mr. Heffernan, which he could give, against Eric Menendez only, and only with respect to two issues. And I would not get into those areas that the defense objected to. However, the defense is not satisfied with that, and they will not enter into a stipulation. So he's going to have to testify.
Well, I don't mind the witnesses testifying. That's why we're here. I just want to know what is the dispute?
Tell me what you want to put in.
all I want to put in is the fact that Mr. Heffernan entered into a contract with Eric Menendez for a period of 8 months, $5,000 a month for an exclusive service from Mr. Heffernan. In addition, Mr. Heffernan trained Eric Menendez from 2 to 6 hours, it appears from the report, per week at $55 per hour, and that he gave Eric Menendez a lesson on the morning of August 18th. Those were the 3 areas that I wanted to go into, and I had offered the defense to stipulate to those, and I would not get into all the areas to which they objected. So that's what I intend to call him for.
And you're not going into testimony of his observations the morning following the
Not at
killings?
this time. I perhaps that would be in rebuttal.
Right. Well, is there any objection to his testimony to those things that the people are offering them for?
We just didn't want to stipulate when we wanted to testify.
All right. So that there's no dispute then. Okay. So he's the first witness. All right. Then the next issues have to do with spending evidence related to the Marina City Club and the Bel Air Hotel. And as far as the Calabasas burglaries, the court had urged counsel to work out a stipulation. And this is the first time I've been informed that you've had some difficulty in arriving at some agreement. And each side has submitted to me a proposal. Regarding the Marina City Club, let's talk about that for a moment. Or, I'm sorry, the Bel Air Hotel. What is it that Ms. Castro would be testifying about?
She's the custodian of records that the records accurately reflect the period of time that that this room was rented, that it was the most expensive suite there at $1,300 a night. And I would also propose to offer a copy of the receipt from the hotel, which was apparently signed. It appears to be the signature of Eric Menendez on the receipt. It's blown up here. This is the same credit card account on which the Rolex watches were purchased. And we would offer this against both defendants. And I believe there's been testimony from Dr. Oziel that he visited them there.
All right. Well, what does it prove?
Well, it proves that they checked into the most expensive suite at the Hotel Bel Air and ended up, the room was $1,300 a night. I believe they were charged for 5 nights because they were a late checkout on the 4th day. And let me just do some quick math. They had an additional approximate $2,000 worth of additional room charges. It's to show a pattern of spending in the period of time shortly after their parents' death. And I believe the court heard the testimony from Mr. Llanio yesterday as to his role. So,
All right. Well, that's what I'm asking. What does it prove? If the room was selected by a relative and they stayed at this hotel, and there's at this point no evidence that the defendants themselves selected the room, but that it was selected by someone else. What does it prove by way of this offer that they were spending money, and it's large sums of money, other than what we've heard here, that someone else made the decision to spend the money?
right. Well, I believe the testimony was that it was done in the presence of Lyle Menendez, that he didn't object. We know from the credit card receipt it was signed for by Eric Menendez on the same account that they used to buy the Rolex watches. And it appears that they were flagrantly spending money that wasn't theirs. I mean, Mr. Llanio didn't pay for it. And that would be the people's offer as to the significance of that evidence.
All right. Let me hear regarding the Marina City Club. What is it that your witness is going to testify about that?
With respect to that, this witness will testify that on October 15th, the defendants came into the Marina City Club office, asked to look at a penthouse suite, went up to the most expensive penthouse suite, which was $990,000, spent a couple of hours up there, came down and said they wanted to purchase that penthouse suite. And on that day, Eric Menendez tendered a check for $29,700 as a deposit on that suite.
right? And the defense had some evidence they wanted to offer in regards to that.
Yes, Your Honor, but our witness is Mr. Goldberg, who's in trial, and this morning had an 8:30 appearance in Orange County, but I can make an offer of proof if the court would like to hear it.
Well, if you want to make it, I'll hear it.
Mr. Goldberg will say that he, on behalf of the family, particularly the Baralds, who were the executors of the estate, that there was a decision made in the family that the boys needed some stability and they needed a home. And therefore, he had encouraged them and was accompanying them in looking at various properties, that this penthouse at the Marina City Club was a property that he suggested to them, that he was present for the discussions, that the deposit was put down on a very temporary basis, that he analyzed the real estate investment value and advised the boys that after he had first encouraged them to look at it, that it was not a good investment, and there never was a purchase of that penthouse at the Marina City Club. And he will say he was involved at every step of the way, and it was the family's idea that they think about buying something. And ultimately, they did not buy anything. Mr. Goldberg was the attorney for the estate, Your Honor, attorney for the executors.
Your Honor, if I might.
And if I might finish. So Mr. Goldberg would testify to that. If we have to call Mr. Llanio back, he was also involved as he's a real estate broker, Mr. Llanio, in suggesting to the boys that they might want to purchase a property, but they were being advised every step of the way by family members and Mr. Goldberg, and they didn't make this purchase. The other thing that's troubling to me is why this evidence would only be, I mean, if their theory is right, that they are on a spending spree, I don't understand why they then decide this evidence is only admissible as against Eric.
That's beside the point and not subject to this hearing.
The second issue is they have also presented us today with lease agreements. Ultimately, both brothers leased apartments in the Marina City Club. Eric moved into his with a roommate who shared in the rent, and Lyle moved into his with a girlfriend. And we would object to the admissibility of the lease agreements because clearly they had to live somewhere. And we can imagine what the people would be saying if they chose to live at the Elm Drive house. Instead, they needed a place to live. The family was encouraging them to find a place to live, and so they rented 2 apartments. In November,
I haven't heard the prosecution in its offer of proof refer to lease agreements. The people referred only to the proposed purchase of a penthouse.
Your Honor, that is correct. There was this proposed purchase that didn't go through, and it wasn't because of Mr. Goldberg. According to this witness, it was because Lyle Menendez told her that he was purchasing restaurants back east and he wouldn't be in town that much, so they decided to rent condominiums. Lyle's being a condominium for $2,150 per month, and Eric Menendez rented a condominium for $2,450 a month, referred to by counsel in a pretrial motion as just a little colonial apartment at almost $2,500 a month. So we would intend to present that as well, in as much as I believe they're going to point out that the original $990,000 purchase of the most luxurious penthouse suite in the Marina City Club towers fell through. And she has information that Lyle Menendez didn't want to go through that deal because of his business interests back east.
again, I ask, how then is this transaction admissible against Eric? Moreover.
Well, are you offering Lyle Menendez's statements against Eric Menendez in some fashion?
I would intend to, if the defense brings out the fact that the agreement, and I think it should be brought up, that the agreement wasn't consummated, that they didn't end up purchasing it. I think it's relevant as to why it wasn't purchased.
Well, it's hearsay, is it not, if you're introducing a statement attributed to Lyle Menendez?
Well, I don't think we're offering it for the truth of the matter asserted. That
Sure
is
you
that
are.
that is that he had these interests back east, and it would be in front of Eric Menendez's jury.
Well, you're offering Lyle Menendez's statement in front of Eric Menendez's jury to prove that that's why Lyle Menendez didn't go ahead with the purchase, because he had some business interests back east. So that's hearsay, isn't it?
Your Honor, at the very least, that particular statement of Lyle Menendez does contradict the offer of proof that they proposed by Mr. Goldberg. Whether or not it's in front of the jury, that does contradict it.
Well, it doesn't contradict my client's state of mind. Whatever Lyle chose to say to get to make excuses is not what Eric's reasoning was. Moreover, Lyle could have been fibbing.
Okay, in regards to this issue of purchase of condominium at the Marina City Club, and where ultimately the defendant, Eric Menendez, resided, there has been, I believe, some evidence as to where he lived at some point that's been presented to the jury. Evidence as to where he moved after the killings in the house. The court, based upon the offer of proof and the defendant's offer of proof, finds that as far as the Bel Air Hotel is concerned, and after having heard the evidence from Mr. Llanio yesterday in regards to how the room was selected, and having heard that it was selected by Mr. Llanio, not by the defendants, that it was selected for the purpose of being a place where not just the defendants, but family members would congregate, and did gather after the killings and for several days in anticipation of going to New Jersey for some function relating to the funerals. That in that regard, it does seem that the evidence is ambiguous at best, and the probative value of it is substantially outweighed by the potential confusion of issues. And really, it doesn't have any relevance in that it doesn't prove anything. That they were at a place, and the place was selected by somebody else, and ultimately there was a bill that had to be paid, and someone paid it. Doesn't establish the state of mind of the defendants in spending large sums of money. In regards to the Marina City purchase or proposed purchase and rentals, that occurred 2 months or month and a half after the killings. The defendants, contrary to counsel's reference to them as boys, were adult males, and were capable of making their own decisions as to where they wanted to spend their money, whether or not the family had input into it. And it's a decision that they were making, and it is a reflection of their state of mind as to intent to spend large sums of money very shortly after the killing of their parents. And the court finds that the probative value of that evidence is substantial. It's a reflection of the state of mind of the defendant, and the potential prejudice and potential for confusion of issues and undue consumption of time is not substantial. And the court finds the probative value of the evidence substantially outweighs any potential for prejudice, and the court would permit that evidence before the Eric Menendez jury, since it is being offered only as to that defendant. The court finds that this is probative evidence as to the state of mind of the defendant, Eric Menendez, shortly after the killings, to spend large sums of money that were derived from the killing of the parents, and would be reflective of his state of mind at the time the killings occurred. And therefore, that evidence will be permitted. Regarding the burglary in Calabasas,
I'd like to be heard on that.
yes.
Court had ruled that the only reason, I understand the court's explanation in the ruling in the past, the only reason why the Calabasas burglaries were relevant was not because of similar crime rules, because it's not a similar crime, but because it was the reason why Eric and Lyle were referred to Dr. Oziel, and it reflected, therefore, upon the family relationship think the court made comments about the parents and their attitude towards the children might be based upon the Calabasas burglaries rather than the fact that they were merely bad parents. And so it was in the context of explaining the family relationship that Dr. Oziel was therefore permitted to talk about the Calabasas burglaries and why the people were therefore able to get that evidence before the jury. Well, the evidence is before the jury, and there is no rationale for proving up the facts and circumstances of those burglaries except for prejudicial purposes. There is no showing that the parents who were not present ever knew the specific facts and circumstances of the burglaries. Now, our concern about the people's proposed stipulation has to do with the fact that just
Go back, you said there was no showing the parents knew the circumstances of
they
the
didn't know
burglary.
the specific circumstances. They know that Eric and Craig Signorelli were involved in finding the combination to the safe at the List House.
Well, without going into your understanding of what they knew, isn't there
there's no
some
showing.
other evidence that the father knew based upon conversations that occurred between the defendants and Dr. Oziel, that the father was critical of the way the burglaries occurred and things of
Only
that
that-
sort? And
only
that
that
was one of the
yeah.
sources of dispute between the father and the sons, that they were upset that he was so critical of the way they performed this
Well,
burglary.
what's the facts that you have, Your Honor, about what the father knew? That's all you've heard. That's all there is. If I may finish. There's no showing that he knew anything about the specifics of how they got into the house or didn't get into the house or how they found the jewelry. The only thing that he's critical of is that they got caught.
Well, you don't know that.
Well, that's all I know, as much as you know, and that's what those conversations indicated, that they were so stupid they got caught.
Didn't the father go to the police station when the defendant, Eric Menendez, surrendered?
Yes,
Do you know if he was present when he was interviewed by the
Yeah,
police?
we
Do you know
don't.
one way or another?
but we based our stipulation on Eric's statement.
Was there a probation report prepared? Do you know whether the father was at the probation hearing and saw the probation report?
No.
Was there the report prepared by Dr. Oziel? Was that something that he had access to? Does that have any reference to these incidents?
It has no reference.
I'm just curious as to how you limit the knowledge of the father to just the fact that they committed a burglary and were caught.
Well, I'm just curious as to how anyone could impute knowledge to him without knowing what he knew. All he knew was that, all that's on the record is clearly that he knew that property was taken and he made restitution for the property. And there's no indication that he knew, and he knew Craig was involved and he knew Lyle was involved. But beyond that, even the evidence for Craig is that Mr. Menendez threatened to kill him because of his involvement in the burglaries. So beyond that, there's no evidence of what he knew or didn't know. But as far as my biggest concern with the people's proposed stipulation is that, just as in the Aranda issues, they want to make it look like Eric did this on his own, and that's hardly the case.
Well,
And they have in Craig Signorelli's own handwriting his admission that he was present, that he helped find the combination to the safe, that he was there when it was opened, and yet they want to leave that out.
Well, Eric Menendez is on trial, not Craig Signorelli, so the relevance has to do with Eric Menendez, not Craig Signorelli.
But it's also relevant that he did not act alone. That also bears on his culpability.
Well, let me hear from the people.
It was my understanding when I brought the motion to admit this evidence, it was under Evidence Code Section 1101B, and I offered that this was relevant evidence as to motive. The motive being that, one of the motives being that Mr. Menendez had criticized the brothers for the way they did the burglaries in Calabasas, that the statement was made to Dr. Oziel that they were upset with him criticizing them. In fact, they said that they would have gotten away with those burglaries except that their father had turned them in. And in fact, the father did turn in Eric Menendez and showed up on September 16th of 1988 with the property, including VCRs, computers, jewelry, safe, all these articles of property worth almost $100,000. So there's no way that Mr. Menendez didn't know the severity of the crime and the property that was taken. In fact, Mr. Menendez is the one who had to make restitution of the property that was not returned, the property that was used up by Mr. Eric Menendez, including money. And there's a statement by Eric Menendez in a statement on September, I believe it's 16th, when he confessed to the burglary at the behest of his father, it appears, is that after he did the list burglary, he took money from that safe and he used some of that money to get articles in which it made it easier for him to do the Ginsburg burglary, which was subsequent to the list burglary. So it was my understanding the court's analysis under the 1101B was that under 352 that there's relevant evidence as to family relationships on top of the motive evidence under Evidence Code Section 1101B. So I think counsel's recitation of the facts as to the analysis of that motion, the 1101B motion, is inaccurate. I think it goes to motive as well as to the family relationship.
Your Honor, if I could respond briefly.
Well, let me say that the 1101B analysis is not really opposite. It's not the typical other crime evidence that is offered to show motive per se. This is offered for other purposes, and it's offered to show, number one, as we referred to before, the relationship between the father, mother, and specifically the father and the defendant. And it is relevant evidence in that it relates to the statements attributed to this defendant, Eric Menendez, in regards to why he killed his father. That one of the reasons was the father's demand for perfection and the defendant's inability to deal with the father's criticism in relationship to this incident. And that was in testimony of Dr. Oziel. And also, in addition to that, there are other factors that come into play, including the efforts of the father to, as the prosecution indicates, to make restitution for the activities of the son and to accompany the son to the police station at the time he surrendered.
Well, Your Honor, we've certainly offered in our stipulation the fact that the father was involved, that he made restitution, that he accompanied him to the police station. He didn't turn him in. This was all brokered and negotiated by Mr. Chaliff.
Well, I assume Mr. Chaliff wasn't hired by Eric Menendez, but he was hired by the father, and that to make it seem as though the defendant was involved in selecting the attorney and making the arrangements is rather extreme.
That's not my point. The point is not, though, that the father, that when Eric went to the police station with Mr. Chaliff and his father, that his father was turning him in. This was all worked out in the family, that Eric should take the fall for Lyle. And therefore, it was all worked out where Eric went in with his lawyer with all of the property and confessed. And in his confession, he shielded Lyle. And he shielded Craig Signorelli because the concern was that Craig Signorelli, if arrested, would blow the whistle on Lyle. But in going back to the court and Mr. Furriano's analysis, there's a few things missing. First of all, it is not in Eric's statement that he used money from the list burglary to purchase Ginsburg articles. I believe that's a statement. Is that a statement attributed to Craig, Mrs. Morrison?
It's not a statement attributed to.
All right, what else?
And the other thing was that the discussion with Dr. Oziel, the supposed discussion about motive based on the burglaries, if I understand it correctly, that was a statement of Lyle's, that the father mocked them, that they did such a bad job, and that his father would now be proud of them. That was a statement of Lyle's that was attributed to Eric, so that's fairly tenuous.
But that was admitted before the Eric Menendez jury?
Yes, it was, but my point is that to then go back to that and say that's a foundation for a notion that the motive to kill had to do with being mocked when those were Lyle's words to begin with is stretching.
If I may, Your Honor.
Yes.
With respect to counsel's statement, this appears on a memorandum of the Los Angeles County Sheriff's Department. Quote, He also indicated, this is Eric Menendez in his statement on September 16th, 1988. He also indicated that he used some of the money he had stolen in the List burglary to purchase certain articles which he used in the Ginsburg burglary, but refused to elaborate. And in the next sentence, Mr. Chaliff stated, so it was during that period of time when the confession was being made to the detectives that he made the statement that he used the money from the List property, that is the money he took from the List safe. He used that money to get implements to help him with the further burglary of the Ginsburg residence.
I take that remark in. I'm sorry. I was misled.
Well, the issue really is as to how much detail should be included in the stipulation. And the court encouraged counsel to engage in negotiations regarding the stipulation for the purpose of avoiding litigation on what could be a collateral issue here regarding what happened and all the specifics of these burglaries. All the detail of it is not necessarily relevant. But there is some information that the jury is entitled to hear. They are not to consider this evidence to show bad character of the defendant. It's not being offered for that purpose. It's being offered solely to show, number one, as the prosecution indicates, although it's not the usual offer under 1101 of the evidence code, to show a motive not directly based upon another crime, but based upon the father's reaction to the crime, how it was committed, and the criticism of the way it was committed. And also to show the relationship of the father and son, and to rebut the inference that has been suggested by the defense that the father had no concern for the welfare of the son, and also to show that there was another reason or other reasons why the father might have been concerned about the son's behavior and conduct that the defense has referred to as basically being an overbearing father figure. And when a son gets involved in activities such as this, which is not just minor mischief, but major criminal activity, breaking into 2 houses and stealing large amounts of property, the father had a legitimate right in being concerned with and having a certain attitude towards a son who's been involved in that sort of activity. And it also could have relevance and bearing on the father's concern for which friends the son had, things of that nature, and also has bearing on such issues as why the son was under treatment by Dr. Oziel, and is relevant on that issue as to why this therapy was begun. And it was because of this Calabasas burglary and not because of some other issue that has not been presented to the jury, but related specifically to this Calabasas incident. So there are various reasons why this evidence is relevant and probative evidence, and the probative value substantially outweighs any potential for prejudice. But again, the court's concern is that this not get into a situation where we have a trial on this matter, that counsel can negotiate further as to the specifics of what it is that should be presented to the jury, bearing in mind that if you work out a stipulation that in essence it should encompass what could be brought out by the defense in examination of the prosecution witnesses that you would call in this matter, as well as what the prosecution would obtain if witnesses were called. And the purpose of the stipulation is to avoid the appearance of these witnesses and their testimony, and to avoid the undue consumption of time that would arise from litigation over what the specifics were that did occur. So I'm going to ask that council confer further on that subject to see if you can arrive at a resolution. Both sides, I think, have an incentive to do that. And if there isn't the concession, then there would be testimony. And if one side or the other is reluctant to have that testimony, then, or both sides are, then you should work out an agreement. So I'll let you talk about that a little bit more. Well, the rationale that you meant to fail to grasp is that the people are only offering it against Eric Menendez. So
Object based on discriminatory prosecution. That
All
they
right.
seem to be selecting things to admit against Eric for reasons that are, make no rational sense if they had equal evidence against the co-defendant.
all right, well, that's clearly a trial tactic and decision made by lawyers during the trial as to what evidence they seek to introduce as to which defendant. And I don't think it rises to the level of constitutional challenge.
Well, of course, they cannot use, I take it, this is the court's indication of the documents hearsay problem. They cannot use Lyle's reason for canceling against Eric.
I ruled it's hearsay. All right. The other matter had to do with the so-called BBC movie.
Yes, Your Honor.
Just give me a little more information about
Yes.
that, please.
Your Honor, when we got the information from Dr. Oziel, I believe it was in December of 1992, reading the notes of the sessions of October 31st and November 2nd, the notes indicated that there was a BBC movie special. That
When did you first become aware of that?
When we got the tapes, the Oziel tapes from the Supreme Court, and I believe it was
November 30th.
November of 1992. We went to the grand jury in December of 1992.
Okay.
At that point, Your Honor, reading about this movie that was the catalyst that led to the discussions of the brothers, the person on the movie being similar to Eric Menendez's father, according to Eric Menendez, and being the impetus to these discussions on how to kill their own father, we set out to find this movie. It included calls to the BBC, the British broadcasting company. It included Detective Zoller calling to Scotland Yard to find out whether a similar sort of killing had taken place. It involved looking over old TV times from the LA Times to find out whether we could locate a movie that occurred. According to the grand jury testimony of Dr. Oziel, the BBC movie that Eric Menendez was watching, this is in the grand jury transcript at page 349 and 350, preceded the murder by several weeks. We then got several TV Times magazines. I received 4 or 5 of them from a friend of mine in the office who keeps them, has kept them for about 10 years. I went through
Who is
those.
that strange person?
That is.
Well, never mind. You don't want to put that name on the record. Okay, go ahead.
Just write it on yellow.
I have to say he's a fine deputy DA. I reviewed those, Your Honor, and what we were doing at the beginning, we believed it was a British broadcasting company. So we looked at these TV Times. In fact, I believe Detective Zoller looked through some microfiche, tried to find a movie that appeared or was shown on television some weeks before the murders. In fact, recently, Deputy Bazanich went to the local library and got a card and took out some TV guides. The TV guides are a little bit more comprehensive, and we went through those TV guides to try to find this BBC movie. Well, as it turns out, last week, Dr. Oziel testified as to the BBC movie. And at the end of the week, I was a little concerned that we had not found the movie. I discussed with my wife, we're going to be resting our case soon. And Saturday night, we went to the video store to get a video for my daughter. What happened is...
Evidence goes to section 352 could apply to this offer of proof.
Oh, okay.
It's getting
Well, I'm just trying to
rather
explain.
prolonged,
I'm just trying to explain
Okay.
what happened. On last Saturday, my daughter wanted to see the Addams Family, and my wife went to get the video from the Addams Family shelf, and right below it was a Billionaire Boys Club.
Eureka.
And my wife said, you're talking about the BBC movie. What is this it? So I said, I took the cover, the BBC movie, went to the guy, said, do you have this movie? He said, no, but it's going to come in tomorrow. So last Sunday, I rented that movie. I watched it, and it sent chills up my spine. The similarities between this case and that movie are astounding. And what I did is I watched that movie, and if I may, just very briefly, Your Honor, is the movie is basically about two murders, one being the murder of Ron Levin, who, according to the movie, was shot in the back of the head. They used shotguns later on Ron Levin, according to the movie. Suspects were the mafia and the cartel, and you see Joe Hunt on this movie talking about the perfect murder.
Is this a documentary or a
No, it's just a made-for-TV movie. It's a
fictional account?
Yes, based on the Billionaire Boys Club from Beverly Hills. What happened then is Joe Hunt talks about the perfect murder, and he refers to the date that he had killed Ron Levin as June 6th, and he said, we need an alibi. What was the alibi? The alibi was a movie. They went to a movie that night, just as Eric Menendez and his brother claimed that they were at Batman that night. Now, later on in the movie, there is a son who is actually the Llanio son.
Who?
Llanio. Llanio was the second murder victim of the Billionaire Boys Club.
That's the one where Mr. Hunt hung up the jury, is that?
Yes,
Oh.
and Llanio, the son, was convicted, and he received life without the possibility of parole up north. Now, what happened in the movie is Masood is the son of Llanio, but his name in the movie is Bejan Nabodi. Now, what he does is he goes to the BBC and says, I hate my father. My father's basically a jerk. He made my younger brother put a cigarette out in his own palm. And he stated, my father has $30 million. We should kill him. The BBC says, that's a good idea. They kidnapped him. The plan was to kidnap him, make him sign over his money, and then kill him. But what they did is they kidnapped him, put him in this crate, and he suffocated. Now, in the movie, Bejan Nabodi says, my father has political enemies. He was in Iran. His enemy is the Ayatollah. We could just say that the Ayatollah, it was a political killing of the father. Now, defendant Eric Menendez claims Castro killed my father. He gets all these ideas from this movie. As Dr. Oziel testified, Eric Menendez hated his father, and he said he got disabused of the notion of killing his father from this movie, and called his older brother, over and said, "Look at this movie. This is like our dad." Indeed, in the movie, Joe Hunt drives a Jeep. Eric Menendez bought a Jeep after the murders. Joe Hunt wears a Rolex watch. Eric Menendez had a watch. It is connected further by Eric Menendez's own mouth on November 29th, 1989, at page A5 of 33, in which he talks about Brian Llanio, who is the younger brother of the man who was convicted of the killing of Mr. Llanio up north.
Who's talking?
Eric Menendez.
On
Eric
what
Menendez.
tape now?
Pardon me?
This is the tape with Signorelli?
Yes, November 29th. He says that Brian's father was the head of the secret police in Iran. And at A1 of 10, he states Brian Llanio. And then Eric launches into this statement about forming a group of friends into a corporation. They'll make millions of dollars. It's kind of a loosely organized corporation. They talk about inventions and investing, just like the BBC. And in fact, Craig Signorelli states, Craig Signorelli being one of Eric Menendez's friends, as well as Brian Llanio and two other men, he says, "This sounds like the BBC." And Eric Menendez responds, "Like the BBC." So those are statements by Eric Menendez himself on November 29th. So I think the relevance is shown through his own mouth. And the movie, Your Honor, after I saw the movie and I saw how similar it was, and there's no question about it, that's the movie that Dr. Oziel refers to, Eric Menendez saying that he saw that night, even though we went on this British Broadcasting Company search for all these months. I then checked the TV times that I had, and indeed on July 30th and July 31st, the Billionaire Boys Club aired on Channel 4 NBC from 9 o'clock to 10:30.
On what date?
On July 30th and July 31st, not less than 3 weeks before the murders.
All right. And what did you intend to do with all this?
I intend to show the jury, I believe it's about an hour and a half, this video.
You sell popcorn or?
Well,
What is the purpose of it?
well, the purpose of it is to show that there was indeed this movie that aired and to support Dr. Oziel's testimony that that's what Eric told him. And it's further supported by Eric Menendez's own voice, saying that he mentions BBC himself. He mentions Brian Llanio himself in the statement in November 29th. And if I, just as an aside, if I were a juror and I heard that there was this movie that supposedly showed several weeks or a couple of weeks before the murders, and it was a movie that could be found, that the jury would expect us to put that evidence on.
Well, can't you put on evidence that on July 30th and July 31st, there was a broadcast on Channel X that was entitled BBC?
Yes. And then explain, have.
No, that's all it was, that really that Dr. Oziel heard from the defendants, that there was something in there
Yeah.
about a father and the defendants reacted to it.
Right. However.
But why do you have to go into the showing of the movie? What would that prove? Aren't you trying to, by showing the movie, show that whatever occurred in the movie occurred in this case, and the jury should basically make their decision on what happened in the movie?
No, I think the purpose of the showing of the movie would be to demonstrate to the jurors what Eric Menendez saw that day, and how he stated that the man, as depicted in the movie, the father, was just like his own father, and he hated him. So I'm not sure if the court, if that's sufficient evidence to say that there was a movie called The Billionaire Boys Club that aired on the 30th and the 31st of 1989 without getting into any of the particulars at all of the movie itself.
All right, let me hear from the defense.
Are we gonna have Mr. Curiano's wife testify to the contents of this movie?
No, let's just hear just your brief
Let's go
response.
through that.
Just your brief
Number one,
response.
Dr. Oziel, who you would think would be the source of the most information about this, obviously has not confirmed this theory since he did not testify to it. Nor did he testify before our jury that the movie was several weeks before. The only time span he gave was that the discussion was about a week before the killing and nothing else. And according to his notes, the court reads, the sequence in the notes would appear that the movie, the discussion, and the purchase of the guns all happened with no appreciable break in time. This is pure speculation that whatever movie Eric was talking about was this movie. It's nothing more than that. And the people are trying to use that for the most prejudicial of possible reasons to show that Eric is a killer like the people in the Billionaires Boys Club. The fact that he knows or made reference to Brian Llanio, the youngest son of one of the victims, is no more significant than the fact that Detective Zoller was the investigating officer on the Billionaires Boys Club. So what? But it also would cut the other way. These killings, I'm sure Detective Zoller could give you better information than I, but the Billionaires Boys Club movie, as I understand it, was first made and shown in 1987. And the actual crimes, I believe, were 85 or 86. And it's been replayed a zillion times since, as recently as 3 weeks ago. And one would assume, if one's going to make speculative assumptions, that if Eric knew the Llanio son, he would have known about this without the need of any movie to inspire or serve as a catalyst. It is a more specious theory even than the screenplay theory, to base a jury's determinations on a fictional account. The people have no evidence whatsoever that Eric Menendez saw the Billionaires Boys Club Skate-8 rerun on July 30th or July 31st.
Well, they have Dr. Oziel's testimony referring to BBC, and this would be corroborative of his testimony that there was reference to that in the defendant Eric Menendez's statement to Dr. Oziel.
But it doesn't say, it said he saw a movie on the BBC. Mr. Kuriyama made the obvious, and so did the press, and so apparently did Dr. Oziel, the obvious impression was they were talking about a British broadcasting corporation special of some kind. The fact that they haven't been able to find it doesn't make any difference. Dr. Oziel did not testify that it was the Billionaires Boys Club. He simply used the initials BBC. And it wasn't a special about the BBC. It was a special on the BBC. And that's the end of the record. They interviewed Dr. Oziel, the prosecution and Detective Zoller in June 21st, I believe, or June 22nd, about this movie. And they were asking him questions, and he clearly did not know the content of the movie. And he clearly did not know what movie it was. Now, to jump from that to speculate that what Eric was referring to was something that aired a month before is just wild speculation, particularly when the jurors probably know what the Billionaires Boys Club is about. It's about a bunch of youthful killers. And so it has prejudicial impact, even if it's only mentioned in passing.
Well, except
And
that.
Oziel said on redirect that it was British Broadcasting Corporation.
No, I think you.
No, that was objected to, and I believe it was stricken, is my recollection, that you
Where's the
objected to
transcript? I
that.
have it marked in the transcript.
That you objected to it.
No, just.
That he didn't know. He just, BBC, and that's all there was. My view is that I'll let counsel review the testimony of Dr. Oziel to find any references he made to this movie or the TV show that was referred to by Eric Menendez. And this is, again, only offered by the prosecution in relationship to Eric Menendez, since it was in his statement that this reference was made.
Your Honor, if I might, at page 10,635, Dr. Oziel stated, Eric told me that the discussions began with Eric watching a movie on the BBC that related to a theme that someone in the movie had a similar relationship with his father, whatever, and apparently killed the father in the movie. And somewhere in the midst of that movie, Eric called Lyle in, and Eric related, as I recall, that after sort of a casual conversation to begin with, where the conversation was something like, well, I wonder what it would be like if the person who did all of this in our life was gotten rid of, or wasn't here anymore, or eliminated, or wasn't around. And that is how the initial discussion of planning to kill the parents began.
All right, there was other reference to that in other examination of the witness, and I recall something regarding British Broadcasting Corporation, and one side asked the question, he gave an answer, and the other side objected, and it was stricken as a conclusion because the only reference was to BBC.
Be that as it may, Your Honor.
My view is that unless there is some further reference in the transcript that counsel want me to review that would bear on this subject, that it does have relevance to corroborate the testimony of Dr. Oziel, which has been the subject of attack by the defense, that there was such a show on television in Los Angeles that was available to the defendants.
Well, Your Honor,
And let me finish, and that it was played on July 30th and July 31st, and it related to the Billionaires Boys Club, which I'm sure some witness for the prosecution can say is also referred to as the BBC. As far as the content of the television show and what it had on it and what the storyline was, at this point, under Section 352 of the Evidence Code, the court would find that the prejudicial impact of that substantially outweighs its probative value. But the reference to it as being broadcast on that date and the name of the show would be admissible.
Your Honor, is that without prejudice to renewing our motion later on or for the subject of cross-examination of various defense witnesses?
Yeah.
Okay.
Yeah, this certainly can be renewed at a future time if there is some relevance to it, but I don't see how you at this stage can justify the offer of proof of playing this tape for the jury.
Your Honor, I just want to make it one thing. I think if the purpose is to corroborate what Dr. Oziel said, then the only thing that's corroborative is that there was a movie where the initials of the movie were BBC. And then he's corroborated without mentioning Billionaires Boys Club, because most people in Los Angeles, particularly since it showed 3 weeks ago, and we didn't admonish the jury not to see it, some of the jurors might actually know content. And if we get into
Well,
that.
3 weeks ago, most of us, I suppose, didn't have any reason to admonish the jury.
Exactly my point. No, I'm not saying you should have, obviously. Nor do I think they should be admonished about that now, because I still don't think it's relevant. But if what's relevant is the corroboration of Dr. Oziel with the initials BBC, that's all that the people should be allowed to show. And not anything about the content of that movie where the crime is not at all similar. I'm just going on Mr. Kuriyama's description because I've never seen this film. And I remember reading about the true case, but this is not the true case. This is a fictionalized account of what supposedly happened. And we know how untruthful it is since Mr. Hunt just got the charges dismissed against him, although according to this movie, he is the ringleader of the plot to kill Mr. Eslamenia. And it should be pointed out that Mr. Eslamenia, the victim in that case, was the head of the Savak, the Iranian secret police.
Well, as I said, I'm not going to get into the details of it. There could be, however, if you want to limit it to the initials BBC, there should be some reference to the subject of the movie in some way, that there was something to do with father being killed, so that it does corroborate the testimony of Dr. Oziel that is what was told to him by your client.
But then the jury is going to think it was a similar crime.
No, they won't.
No, it wasn't.
No, they won't consider anything other than the fact that there was something about the killing of a father in that show, so that it does corroborate his testimony, which, as I said, has been the subject of great attack. Your argument is
We
that
get punished for cross-examination.
your argument, no, you don't. But your argument is that apparently your argument is that this has all been made up by Dr. Oziel, and that he made up these statements, and here is some corroboration independent of his testimony that corroborates what he says.
Well, I think until the defense is heard so that the scope of the attack on Dr. Oziel is better understood, I think the court is speculating. We're not claiming that he made up everything. We're only claiming that he characterized things in such a way to protect himself. And I think it's obvious that we're not claiming that he made up everything, since in my opening statement, I gave some of the same details of the actual commission of the crime as he claims to have. But there's one other point.
Well, the detail that you don't seem to adopt is one regarding premeditation and deliberation and planning and intent, which could very well be corroborated by your client forming an intent to kill on July 30th or 31st, which was a month before the killings.
Well, there's
3
one
weeks
other
before the
small
killings.
problem, however, and that has to do with the court being given truthful information from the prosecution. They not only cannot prove that my client was in Los Angeles where this movie was accessible to him, but they know very well he was not. The entire family was not in Los Angeles on July 30th and July 31st, and they have interviewed the people who were babysitting their house and know they were not there.
You know, I don't think there's anything in Dr. Oziel's statement that says they were in the room in which they killed their parents watching this movie. It just says that Eric was watching the movie and that he called Lyle into the room with him. It doesn't
Well,
say.
this is the first I've heard that they weren't in town
They
on
were
the dates
not.
that this thing was played. Where were they? Do you know?
Counsel seems
Oh,
to
I'm
know where
not,
they are.
you make your offer, counsel. It's your evidence. Where were they?
Can you show that the film was available to the defendant where he was? That's the issue.
It played on NBC, and I'm not
It
sure.
was a network show?
Yes.
I would have to call NBC to find out what areas they showed
Okay,
it.
so it was on the NBC, so
Channel
the
4.
national broadcast. Is that what
That's
you're
my
saying?
understanding. It's a Sunday night special movie.
They don't know where the defendant was.
Well, maybe,
I mean, they
Yeah,
have to
if
make
they-
a relevant nexus.
Well,
They can't.
argument is that they were somewhere in the United States, I assume. is
Yes.
what
They
you're-
prove they're somewhere in the United States. I don't think they can even do that.
Well, I don't know if they can or not, but
Well, he did see the movie, so he must have been somewhere around here.
Oh, snap.
okay. Well, it seems to me that that might be an area for the defense to chip at, but as far as the admissibility of the evidence, I still find that if it's a national broadcast, if there's some dispute whether they're in Los Angeles or not, it still wouldn't negate the opportunity to see the movie. And
Would the court consider our request to limit, to not use the terms Billionaires Boys Club because the jurors may have seen that movie and use that information inappropriately?
well, as of now, the words Billionaires Boys Club have not been presented by the witness, Dr. Oziel. It was referred to by Mr. Signorelli, and then it was stricken
Because it was
in his
Mr.
testimony regarding his conversations with the defendant as far as their ambitions, desires, what they wanted to do. But
Mr. Signorelli had brought it up, Your Honor. It was his.
no, he was testifying about his conversations with your client as to their joint plans and
Yes,
their
he-
future. Okay, let's get beyond that. The issue is that Dr. Oziel referred to it as Billionaires Boys, or rather BBC and not Billionaires Boys Club. However, he did refer to it as a movie that related to a son killing a father. And the court would permit reference to that as BBC and a movie of a son killing a father. And that would be the extent of it at this point, because it does corroborate the testimony of Dr. Oziel, and as I've already ruled, the probative value substantially outweighs any prejudicial effect. And obviously, the area can be explored further depending upon what is introduced during the defense. Maybe it'll never arise again, I don't know. So that's how we'll deal with that issue.
I guess it's to cancel the copy.
Are we ready with
Mr. Goldberg.
Mr. Heffernan? Is he going to be the first witness? And then you have Marina City Club, which is offered only as to Eric Menendez, is that
Your Honor,
right?
before we get to that, Mr. Goldberg is here, and I would like to make a record and put him on to testify to what he would say about the Marina City Club.
Okay, we'll do that after Mr. Heffernan testifies, and we have both juries here because we told them to be here at 10:30, and we'll see if they all are here. And then we'll proceed.
I'm sorry, I tuned in
Yes.
late. I don't believe Mr. Heffernan is going to be testifying in front of Lyle Menendez's jury.
Is that right?
That's correct, Your Honor. I spoke to Jill Lanson and also the Marsha Morrissey, and we decided that instead of getting into all these issues now, that I would just put on the three areas that I have already stated as to Eric Menendez.
I thought there were two.
Well, there.
All right, then we'll proceed with the Eric Menendez jury, and then unfortunately, I was under the impression that we would have evidence for both juries this morning, and the Marina City Club is only offered as to Eric Menendez as well, is that right?
That's correct.
How about
And
Detective
also the
Zolman?
BBC is offered as to Eric Menendez only.
Correct.
So what is there for the Lyle Menendez jury at all today?
Well, it was going to be the Hotel Bel Air, Your Honor. That was one thing we were going to put in front of both juries, and we have Detective Zoller for both juries. He's going to have to testify in front of Eric Menendez's jury for some things, particular things to Eric Menendez, and then in front of both juries so we can conclude the case.
Oh, Your Honor, I should indicate, we have a 402, I'm sorry, concerning, since the people want to put on this contract with Mr. Heffernan, we're objecting to that and we want Mr. Goldberg to testify because he's the one who negotiated that contract, not Eric. And I think that bears on whether or not the contract with Mr. Heffernan is relevant evidence of motive, extravagant spending to backdate to motive. So we'd like to put Mr. Goldberg on for both of those issues before Mr. Heffernan testifies.
Was Mr. Goldberg going to spend his money on this, or was it going to be Eric Menendez's money?
I don't think that's the issue, Your Honor. I think we've gotten far afield of the court's original reasoning on this. If I remember the 402 hearings that we had, where we presented the case law that indicated that the mere fact that someone spends money after a crime is not proof that money was the motive. The court's initial reaction was, excuse me, Well, extravagant spending close in time, excuse me, I'm sorry. Extravagant spending close in time might have some bearing on state of mind before. And now we've gotten very far afield from that kind of logic. Mr. Heffernan was the tennis coach before. This family always had tennis coaches. The average over years
No,
and years.
We heard you argue this one before, and the issue is whether there was a substantial change
There was
from
no
before and after. Well, from a once or twice a week tennis lesson to daily personalized coaching and ambitions to become a tennis pro and all that stuff. There is a
They were trained professionally all the way through. They competed in national competitions all of their life. This was nothing different. He was training with Mr. Heffernan every day in high school. So, I mean, there is no change in lifestyle. It's just like living at the Marina City Club was not a change in lifestyle.
Okay, well, we can hear that if there is some dispute about that. Yes.
I mean, they're living in a
Mr.
$4
Bird?
million house. To move into an apartment is not a move up. I don't
Well,
care how good an apartment is.
Yeah, except that it was a parent's house, not their house. Yes, Mr. Bird.
Judge,
They treated them like property too.
Counsel, let's cut it out.
I think the people indicated yesterday their desire to call Detective Zoller last, and I also believe Ms. Bizanich indicated to me that she may not be able to rest today because of the problem with the burglary stipulation. And if that is the case, is there any reason why our jury should have to remain here all day, since it doesn't seem like they're
Well, we're
Gonna
going
be
to try to
needed.
see if we can resolve these issues.
If, in fact, we have to call live witnesses on the burglaries Monday, we'll go ahead and put Detective Zoller on today.
Oh,
Rest
okay.
as to Lyle Menendez's jury, and then complete that. Okay.
Okay. All right. Let me get a report from the bailiffs. Do we have both juries here?
We're missing 2 on the gold, and I've got last time I checked, there was about a dozen outside and about 3 in the room. So we're
Okay.
missing a few here.
All right. We'll let everybody in then, and then we'll do a count and see who's all here.
May we have a moment to remove the video machine too, since we're not going to
Yeah.
be using it?
Okay, you can do that. All right. Did the defense wish to call Mr. Goldberg? All right. Okay. Let the juror come in. All right, we'll take a short break and give you a chance to speak with the witness, and then we'll resume at 11 o'clock. Counsel wanted to have some brief testimony in regards to evidence being offered by the prosecution. Is the defense ready to proceed?
Yes, Your Honor, we are. Mr. Leon proposed that we also cover another financial need so that it's since Mr. Goldberg is on that as well, we'll be able to.
All right.
In fact, Your Honor, everything that I put in my motion with respect to the spending evidence, if this witness is relevant to any of those items, I'm going to get that one.
What else?
All right, let's go. Come on, let's go. Put them on. Step forward, please.
If you solemnly swear that the testimony you will give in the cause counsel before this court will be the truth, the whole truth, and nothing but the truth, so help you God. Just take the stand and state your name for the record.
Stephen Goldberg, Goldberg, Stephen.
Mr. Goldberg, what do you do for a living?
I'm an attorney.
And do you know Eric Menendez?
I do.
How do you know Eric Menendez?
Eric Menendez is a named beneficiary of the estates of Jose and Mary Menendez, and I am the attorney for the executors for those estates.
As the attorney for the executors of the estates, did you have occasion to give advice to Eric Menendez shortly after his parents were killed?
Yes.
And specifically with respect to investments, did you advise Eric Menendez in that respect?
Yes.
Did you advise Eric on the idea of buying real estate?
I did.
Okay, and what was your advice to him in that respect?
In numerous conversations with Eric and also with Lyle, I indicated to both of them that I thought it would.
Excuse me, Your Honor, as to my client, I'm going to insert the attorney-client privilege.
Well, I don't know if we've had anything established that he is the attorney for either defendant. He seems to be the attorney for the estate. So there's been nothing established that there is a attorney-client privilege at issue here. Did you want to?
Could I just inquire as to what this witness's understanding was of
Sure.
status? Sure. Mr. Goldberg, did you have an attorney-client relationship with Lyle?
Yes, I did.
And are the conversations that you're about to go into conversations that took place between you and Lyle Menendez during the course of that attorney-client relationship?
Some of them would be, yes.
I think that's all I have. I renew the claim of privilege.
All right. Why is it that you have a attorney-client relationship with the defendant, in this case, Lyle Menendez?
During a period of time from approximately October of 1989 and continuing thereafter for a period of certainly at least a year, I acted, in addition to acting as an attorney for the estates, I also acted as an attorney directly for Lyle Menendez on a number of occasions in a number of specific matters, for some of which, in fact, I actually presented him bills and which he paid. I had a relationship with Lyle as a business attorney. I assisted him in the preparation and execution of contracts. I represented him with respect to many business decisions that he was making. I also, I think, whether it's separate and independent, but certainly in addition to, had an attorney-client relationship with Lyle from the period of March 8th, 1990, through and including, at the very least, November of 1990.
All right. Okay, you may proceed. And if there's an assertion of the attorney-client privilege as to Lyle Menendez, then you'll have to rephrase the question.
Mr. Goldberg, let me back up and discuss your relationship with Eric Menendez. Did you have an attorney-client relationship with him that was independent of or separate from your representation of the executors of the estate?
Yes.
And, Your Honor, did you give him advice pursuant to that independent attorney-client relationship that you had with him?
Yes.
Okay. And did you specifically advise him regarding purchasing real estate?
I did.
Did you advise him regarding a tennis contract that he entered into with Mark Heffernan?
Yes, I did.
And did you also give him advice regarding the purchase of a Jeep?
I did.
Your Honor, I will indicate that we will be waiving the attorney-client privilege just with respect to the negotiations regarding these specific items, the Jeep, the tennis contract, and any proposed real estate purchases.
Well, I don't know what you mean by solely in regards to the negotiations. I don't know what communications existed or took place between Mr. Goldberg and your client that led up to these transactions. And it would seem to me that if you waive his advice, then you're waiving whatever input he had that dealt with him to give that advice. So you're getting into more than just one brief conversation, it would seem to me.
Nothing leading up to these, but nothing past the time.
Your Honor, we are not attempting to narrow it as much as the court stated. We simply would waive the privilege as to any negotiations or advice regarding these specific transactions. We do not wish to waive the privilege for events after these specific transaction or be put in a position where it is claimed that we have waived the privilege by putting on Mr. Goldberg's testimony on these limited 3 areas.
You mean waiving it for subsequent events?
Yes.
All right. Well, go ahead.
Okay. I have a packet of documents provided by the prosecution as discovery in this case. I'd like them marked as Exhibit 137, please. May I approach, Your Honor?
Yes. 136, I believe.
No, that was Mr. Brunon's phone number.
Oh, that's right.
We don't know if it was sealed, it was only a request.
No, I believe it was ordered sealed, but it was.
Yes, I acceded to Mr. Brunon's request.
Mr. Goldberg, I'm showing you a packet of documents that has been marked Exhibit 137. Would you look at those and tell us whether you recognize them?
Yes.
Having skimmed through the documents, I do believe I recognize these documents.
And are those documents relating to a proposed purchase of a condominium at the Marina City Club?
That's what they appear to be.
Could you tell me who is indicated on those documents as the buyer of the condominium?
Excuse me, Your Honor, I'm going to propose a privilege claim as to Lyle Menendez because I think the witness is going to go into an area with respect to these documents that is covered by our attorney-client privilege as to Lyle Menendez.
Your Honor, the documents speak for themselves. We can have the court look through the documents.
All right, then you can withdraw the question, ask another one. I believe these are documents that have been presented to me by the prosecution and they're offered proof.
Does your card appear among those documents?
Yes, it does.
And have you reviewed those documents at some prior time?
Yes, I have.
Did you review them back in October of 1989?
I don't have a specific recollection of when I reviewed these particular documents, but that time frame would be approximately correct, and that there's a date on the documents of October of 1989.
Okay. Mr. Goldberg, did you? Oh.
I need to clarify that answer. I can be more precise, but not without going into a matter of what has been claimed as privilege by Lyle Menendez's attorney. I can explain to.
There's no question pending, so ask your next question, please.
Okay. Did you encourage Eric Menendez to invest in real estate?
Yes.
Objection.
Okay. And did you?
Objection leading, but the answer.
Did you give him that advice for any particular reason?
There were several reasons.
Okay. And did you advise him of the rationale behind your advising him to invest in real estate?
Yes.
And why did you say that he should invest in real estate?
There were, as I said, several reasons. One of the reasons was that I thought it was, and perhaps the primary reason, was to establish some stability in his life to have a place, to have a home that was not 722 Elm Drive. And also I felt that, perhaps wrongly, that real estate was a good investment, a relatively sensible thing to do. And I thought it was good both from a financial perspective and from a personal perspective for him to establish some roots and to gain some stability.
Did you advise him about areas that he might explore living in?
Yes.
And was the marina area one of the places you encouraged him to look at?
But the Marina del Rey was definitely one of the areas that we discussed.
Okay. And did you introduce him to any sort of a real estate agent to assist him in looking in the marina area?
Yes.
And who was that real estate agent?
His name was Larry Cohen with Fred Sands Realtors in Marina del Rey.
Okay. Now, Mr. Goldberg, at some point in October of 1989, did you go to the Marina City Club to examine a condominium?
I went to the Marina City Club. I assume that I saw condominiums there, but I definitely went there.
Objection calls for speculation.
Sustain, the answer is stricken.
Okay. Let's focus on
Let
what.
me inquire, other than what was presented to me in the offer of proof by Ms. Abramson, what is it that you expect to get from this witness's testimony at this point?
Your Honor, I expect this witness to testify that he went to the Marina City Club in connection with a purchase which he believes to have been made solely by Lyle Menendez. That Eric's role in the purchase of the condominium, the paperwork has been marked as Exhibit 137, was simply to write a check for Lyle because Lyle didn't have any money. The paperwork that has been marked 137 is all in Lyle's name. Eric's
All right,
name.
let me why don't you get to that so I can hear that evidence then? Specifically, assuming we don't have some objection by the co-defendant.
Did you go to the Marina City Club with Eric regarding a proposed purchase of a condominium?
Eric was at the Marina City Club when I went there. I didn't go there with him. I did go to the Marina City Club to discuss a purchase of a condominium at the Marina City Club.
Okay, so you met him there.
Yes.
Okay. And was anyone else present on this occasion where you met him at the Marina City Club to discuss a purchase?
Yes.
Okay, and was that person who was present Lyle?
Lyle was present.
Okay. And did you have some conversation that day with Lyle in Eric's presence?
Yes.
Okay. And based on your conversation, what is your state of mind as to who is interested in purchasing City Club?
I'm giving
Calls for speculation.
that question on the basis of the claim of privilege, Your Honor. Allow the witness to testify to that.
Well, there might very well have been a waiver since both defendants were present and one spoke in presence of the other, perhaps. I don't know what the issue is. But the way that the question is phrased, it does call for conclusion on the part of the witness.
Thank you, Your Honor. What did you see or hear that day regarding who was going to purchase a condominium or who was interested in purchasing a
I'm
condominium?
going to object to the question and assert a claim of privilege, Your Honor. I asked the court if I could lay a foundation to indicate that if there was another person there, he was there for the purpose of furthering whatever business relationship that Mr. Goldberg was being consulted on.
All right, let me ask the witness in general, do you feel that that question asks you to violate a privilege?
It does.
Okay. Mr. Goldberg, did Eric ever express any interest in real estate prior to your advising him that he should invest for stability and to have a place to live?
I don't have any recollection of him doing that, no.
Okay. And did Eric express any interest in buying the condominium that you saw on the occasion where you went to the Marina City Club and met him there?
Referring to the condominium in Exhibit 137?
Yes.
No, I don't believe so, no.
Turning for a moment to a Jeep that Eric purchased. Are you familiar with that?
Yes.
I have some documents that I'm going to I've marked as Exhibit 138. May I approach?
Yes.
Are you familiar with the documents that have been marked Exhibit 138?
Yes.
And are those documents regarding the purchase of a Jeep?
Yes.
Were you with Eric when those documents were filled out?
Yes.
And did you advise him in making the purchase of the Jeep?
Yes.
What was your role with respect to that purchase?
I assisted him in the negotiation of the purchase.
How long did the negotiation of the purchase take?
Several hours.
And what, more specifically, was your role in negotiating the purchase? What did you do?
I went with Eric initially and looked at a number of vehicles, and upon selecting one that he was willing to purchase, we went through the standard process of offers and counteroffers with the salesperson or the sales manager.
We're going beyond the scope here. The bottom line is, as I understand it, this was a decision that Eric Menendez made to buy a Jeep. Is that right? And you were there to advise him some way that he brought a lawyer along to advise him in buying a Jeep. Is that basically what happened?
He decided to buy a Jeep. I was there and to assist him with the purchase to do it as well as possible. I don't think it needs a lawyer to do that, but.
Okay. All right. Your next, let's go on to something else. This doesn't really prove anything other than that Eric Menendez bought a Jeep.
Okay, and did he try and get the best price possible?
Well, come
for
on,
the
that
Jeep?
doesn't really prove or disprove his willingness to spend money. If he wanted to get a good deal, he got a good deal. But let's go on to something else. This is a 402 hearing, not a trial.
Okay. Concerning a contract with Mark Heffernan for tennis services, are you familiar with that document?
I'm familiar with a contract for tennis services with Mr. Heffernan. I don't know whether an exhibit has been marked.
Okay, I have a contract which I've marked 139. May I approach?
Yes.
Have you seen that before?
Yes, I have.
And did you draw up that document?
I participated in the drafting. It was drafted by my office. Another attorney in the office had primary responsibility for drafting it. I was responsible for discussing the terms prior to drafting and then in making revisions to result in the final draft with respect to the drafting.
Okay. And was that a contract which was from January 1990 to August 1990?
Yes, it is.
Okay. Is there any particular reason why the contract ended in August of 1990?
My recollection is that in discussing the contract with Eric, Eric wanted to make sure that he had the ability to go to college in the fall of 1990, if that was a decision he made by that time. So it was the August date was to coincide with the beginning of the fall semester.
Okay. And what was your expectation, Mr. Goldberg, as to how the monies that were owed pursuant to that contract might be paid to Mr. Heffernan?
That's irrelevant with his expectations.
Why don't you rephrase the question?
How were the monies to be paid to Mr. Heffernan?
Initially, the responsibility for payment would be Eric's. We had engaged in negotiations with a company known as Live Entertainment, which had been extended negotiations for a period of months between the estate and that company. And we had included in a proposal to the company that they sponsor Eric on the professional tennis tour for up to 1 year.
And was it your expectation that the company would in fact cover some of the costs of hiring the tennis coach?
The indication we had from the company was that they were amenable to the sponsorship as part of the negotiations and the deal that we were working out. And clearly, we intended to include at least portions, if not all of the cost of the tennis coach to the company.
And was this a contract that contemplated that Mr. Heffernan invest a minimum amount of time per day working as a tennis coach for Eric?
There was a minimum time commitment of 60 hours per week.
And did it also provide that he was to work full-time as Eric's coach?
In order to state exactly what the contract says, I would have to read it, but I can certainly testify as to my recollection as to the nature of services to be performed by Mr. Heffernan.
So you're saying this contract was between this company and Mr. Heffernan?
No, the contract was between Eric, and it's also, the contract says also Lyle and Mr. Heffernan. The idea was that with the company's acceptance of the sponsorship of Eric, that we would have the company pick up, as I said, some or all of the costs that would be included in this contract.
Is there some document that says that?
There's a series of documents that constitute the negotiations between the estates and Live Entertainment. And those documents do include specific reference to the sponsorship of Eric on the professional tennis circuit for a year.
An agreement to pick up the costs of this contract?
The details of what would be included in the sponsorship were never reduced to writing. The lawyers for the company were asking us approximately what we anticipated the costs would be, and we gave them an indication of the costs which would have included the costs that were picked up in the personal services contract.
And was the potential for reimbursement from Live Entertainment for the costs of Mr. Heffernan something you discussed with Eric?
Certainly.
Okay, so he was aware of that.
Yes.
Okay. And did you also advise Eric that, in your opinion, it was more than likely that Live would reimburse him
overall
for the costs? Or did you give him any kind of an opinion about how likely this might be?
I don't know that we would have discussed it in exactly those terms. I certainly told him that it was very likely, because we had the indication from the company, it was very likely that the company would accept the sponsorship of Eric for a year, and that we had discussed clearly would include paying these costs.
Okay. And in negotiating the contract, did you attempt to arrive at what you believe to be a reasonable fee for Mr. Heffernan?
We certainly negotiated the contract, I would say, aggressively to get the best possible contract that we could.
Mr. Goldberg, returning for a moment to the Marina City Club, did you and Eric ever have any discussions about his writing a check to as a deposit for the purchase that his brother planned to make?
Yes.
And what discussions did you have in that respect?
I'm going to object to the question that calls for privileged communications from my client.
All right, the question has to do with what Eric Menendez said to the witness and what the witness said to Eric Menendez. If you can limit it to that, if it cannot be so limited.
I believe I can answer the question, Your Honor. There was discussion with Eric about making a loan to Lyle.
And that loan was for the purchase of a condominium?
Yes,
And that condominium was the particular penthouse condominium in Marina Del Rey that is reflected in Exhibit 137 that is in front of you. Is that correct?
I'm just trying to think if there's any privilege involved in that, Your Honor.
If you have some doubt about it, then don't answer it.
I'm just asking you about
It
your
was-
discussions with Eric.
It was definitely for a condominium in the Marina City Club.
Thank you. I have nothing further at this time.
Mr. Kuriyama?
Mr. Goldberg, you've testified that you were the attorney for the executors of the estates of both Jose and Mary Louise Menendez. Is that correct?
Yes, and am also still at this time.
Have you, and you also at the same time advised both defendants. Is that correct?
That is correct,
You
yes.
had an attorney-client relationship with both defendants at the same time that you were representing the estate.
That's correct.
Have you ever heard of the term dual relationship?
Objection.
Objection sustained.
Now, is there rules of ethics that prohibit you from such relationships?
Objection.
All right, goes to the witness's state of mind if you ever at that time or since have felt there was a conflict of interest.
If the question is in general, are there rules about conflicts of interest? Of course there are.
In this particular situation that you found yourself in, was there a potential for conflict of interest?
No. Well, no, that's not fair. There's always a potential for conflict of interest anytime you get involved in a relationship. Yes, there were potentials for conflict of interest.
The defendants were the named beneficiaries of the estate, is that correct?
Yes.
They had not received any of the proceeds from that estate, had they?
I'm going to object to that. I think it's calling for privileged communications from my client.
Well, I don't know if it does or not.
I don't believe that it does, Your Honor.
Just distribution of an estate would be done through probate court. I would think be a public record.
That's correct, Your Honor. No, not at this time.
Yet you were advising them on how to spend their potential inheritance, is that
Claim
correct?
privileges to that, as to my client.
All right, limited as to Eric Menendez, please.
As to Eric Menendez,
We claim privilege on that too, because there is no expenditure here of potential inheritance.
Well, let's first lay a foundation if the witness had any knowledge from Eric Menendez as to how he was going to pay for these various items that have been subject to his testimony.
yes, Mr. Goldberg, did you have some conversations with Eric Menendez as to how he was going to pay for these real estate pieces of property that you had advised him to acquire?
I'm going to object to that, Your Honor. There's no evidence that he really did.
Overruled. Overruled.
Yes.
What were those conversations?
Well, there were lots of conversations. The bottom line, the answer you're looking for is that if Eric was going to buy real estate, he would have been using assets from the estate at the time that he received them.
And when was it that you first advised Eric Menendez that he should purchase real estate?
I don't believe I can specify that. It would be, I would think, in the time period of October or November of 1989.
October or November of 1989?
Yeah, it could have been September. I don't know.
Do you have billing records on when you advised the defendant and what kind of fees you received from him? Would that help you?
There are some billing records with respect to conversations with Eric. I don't have those with me.
Would those include your advising him about the purchase of real estate?
They might and they might not.
Now, you indicated that you had advised Eric Menendez to acquire real estate specifically in the Marina Del Rey area. Is that correct?
Overall, I indicated that the marina was one of the areas and was an area that we discussed. I didn't tailor my advice only to one specific area.
That was one of the areas.
Yes,
And you indicated that you had gotten him together with the real estate agent.
that's correct.
When was that?
I would guess that it's late October of 1989. That'd be an educated estimate.
Late
Let me ask you, on October 15th, 1989, or on or about that time when the check was written by Eric Menendez, did you have any understanding as to where the funds were obtained to make that payment?
Yes, I did.
What was your understanding?
My understanding was that
I object to the court's question if the understanding is based on conversations.
All right, based upon what you have did learn from Eric Menendez at that time, since it was his check.
Yeah, my understanding was that the source of the check was a life insurance policy.
And that he was spending the proceeds of, or part of the proceeds of the life insurance policy on his father or his mother's life?
Yes.
All right. And in regards to the purchase of the automobile, the Jeep likewise, was that proceeds of an insurance policy?
Yes.
And in regards to how he was going to pay for the tennis professional, was that based upon proceeds from the life insurance policy?
Yes, I believe so.
Now, with respect to this negotiations or the negotiations that you had with Live, was that money owed to Jose Menendez that you were dealing with?
Yes and no.
What do you mean?
There was some money that was claimed to be owed by the company to Jose Menendez. Clearly, for example, when we talk about a tennis sponsorship, that wasn't something that was owed to Jose Menendez, nor was it to be taken in lieu of anything that was owed to Jose Menendez.
Why
So-
was Live Entertainment negotiating to bankroll this contract or the professional aspirations of Eric Menendez?
I can tell you why I think they were doing that.
Did anyone at the business express to you why they were doing it?
Yes, we had conversations. They were very interested in assisting Lyle and Eric both in getting through this time in their lives and in helping them. There was clearly, in my opinion, charitable intent on the part of the company.
All right, go ahead.
So are you saying that there was money in addition to that which was actually owed to Jose Menendez that they were willing to throw out?
I don't know what you mean by throw out, but they certainly had indicated from the very beginning a willingness to pay more than they were contractually obligated to pay.
That's an unusual situation, I take it.
All right, that's argumentative. Let's go on to something else, please. Was this a company owned by stockholders?
Yes.
Did Live Entertainment enter into a written agreement to underwrite the defendant's career in tennis? Did they ever enter into such an agreement?
No.
Did they ever enter into an agreement to actually pay Mr. Heffernan's fees for the services pursuant to the services contract?
No.
Now, getting back to the Marina City Club, you have the documents in front of you, correct?
Yes, I do.
Exhibit 137. The date of the initial documents is October 15th, is that correct?
Yes.
1989.
Yes.
Mr. Goldberg, you weren't there that day, were you? When they first initially signed up for the purchase of that penthouse suite. Isn't that correct?
I certainly wasn't there at the time that they signed up. That's not to say I didn't show up the same day. It's not clear. It's not clear to me. Sometimes I would receive a phone call, can you come over and do something? And if I had the time available, I might do it that day. But I was not there when these, I don't believe I was there when these documents were signed, no.
So you didn't show them this property. They were there and they signed those documents before you ever got there.
Objection, Your Honor. Question misstates the evidence. It's no evidence that Eric
Well,
signed
it's
them.
argumentative. Rephrase the question.
Okay. Looking at those documents and knowing where you were on the 15th of October, you were not there when the initial documents were signed for the purchase of that penthouse suite, nor were you there when Eric Menendez signed over a $29,700 check for a deposit on that penthouse suite, were you?
Objection, argumentative, and it's also been asked and answered.
Overruled. Were you there on those two occasions?
I was not there when the documents were signed, clearly.
You came, would it be fair to say that you came in?
Yeah, were you there when the check was turned over?
I don't know. I'm not sure that the check was turned over at the same time because I remember more discussion about the check, and I remember discussing the check, and I clearly did not discuss the signing of the documents before they were signed.
So they had made the purchase. They'd entered into the agreement before you ever became aware of that agreement. Is that correct?
Objection to the use of the word vague.
All right. Whoever it was who started that transaction started before you came on the scene. Is that right?
Yes.
Was it done before you gave the defendant Eric Menendez any advice in that regard?
That's the part that's difficult, Your Honor, because there was discussion about the check. Now, whether the discussion about the check was 2 days earlier by telephone when they were talking about doing something, I don't know. I have a recollection of discussing this check, and that discussion could have taken place the day when I got there and the check had been written already. But I had discussion about that check and about what that was. Clearly, the documents that are 137 that bear Lyle Menendez's signature were signed before I reviewed them.
All right, let's make it brief now, Mr. Kirk. Anything else?
Very well, Your Honor. So basically, Mr. Goldberg, Eric Menendez told you that he was interested in buying a Jeep. He knew what he wanted, and you helped him with negotiations
Okay, we've
with the
gone through that
contract.
one.
Correct?
We've gone through that one. Let's go on something else.
Nothing further this time, Your Honor.
All right. Any redirect?
Looking at Exhibit 137, does Eric's signature appear anywhere on those documents except for the check?
I had thumbed through all of the documents before when you asked me to identify them, and I did not notice a signature of Eric's other than on the check.
Was Eric giving Lyle money for a down payment, or was he loaning him money,
Jackie calls for speculation.
if you know?
I accept the privilege if it's based on conversations with Lyle.
I can answer the question without invading the privilege with Lyle.
All right. Is it based upon statements made by Eric Menendez as to his state of mind?
It's based, yes.
All right. The objection's overruled.
It was a loan.
So Lyle was to pay him back, correct?
Again, it's at the privilege if it's based on conversations with Lyle.
I can answer the question. Eric expected to be paid back.
And Mr. Goldberg, Eric never followed your advice about purchasing real estate in any area.
Not to my knowledge.
Did you advise Lyle to cancel the purchase of the condominium?
Jack, claim of privilege is tonight,
All
really?
right. Sustain.
To your knowledge, was the planned purchase canceled?
Same objection?
Well, that would be reflected in the business records.
I can answer that question, Your Honor, I believe. The contract was canceled.
Thank you.
All right, anything else, Mr. Kuriyama, on these matters?
Eric Menendez was legally entitled to enter into contracts at the time of these transactions.
Objection.
Overruled.
He was over 18.
And entitled to enter into contracts.
I knew of no reason why he would not be legally able to bind himself to a contract.
All right, anything else?
No, Your Honor.
Okay, thank you. You may step down. All right, before we hear any further argument, if there will be any, let me inquire of counsel here as far as scheduling. We have both juries who have been here since 10:30, unfortunately, based upon your representations yesterday, that we would have testimony for both of them this morning. Obviously, we don't seem to be in a position to do that. What is your expectation as far as which jury will be in the courtroom and at what time?
I believe that the blue jury would be in the courtroom first, and that the period of time is Mr. Heffernan. Probably 15 minutes for Mr. Heffernan. And with respect to Ms. Hart, perhaps 20 minutes. That's in front of the Eric Menendez jury. I do have some testimony from Detective Zoller on the 1129 statement.
We need a 402 on that now.
Your Honor, perhaps what we could do is put on the two items that we talked about, Mr. Heffernan and Ms. Hart, in front of that one jury. Then I'll do Detective Zoller in front of both juries. Then there's a 402 for Eric's jury that needs to be done, and then we have the burglary problem still. So I can probably go ahead and rest the Menendez jury today. Would that be, I mean, that would be something we should try to do.
So Mr. Kuriyama and I are gonna work out the burglary stipulation, aren't we, Mr. President?
Yes, we're going to attempt to.
All right. What I'm going to do then is excuse both juries until 1:45, and hopefully by then we'll be ready with something for one jury or the other.
Your Honor, would there be a chance of getting Mr. Heffernan on? He has an appointment this afternoon, and I had.
No, I don't see how we're going to do that. We still have to hear a little further argument, and it's just not going to happen. Yes.
I was just going to ask whether there was any reason why we couldn't call Detective Zoller so that the people could rest as to Menendez first, so that our jury could then leave after that, because it appears that if that was done, then all the rest of the proceedings relate to Eric Menendez's jury only. There's really no need for them to be sitting here all afternoon.
What is the prosecution's response to that?
Your Honor, I wanted to rest in front of both juries at the same time. If it appears that we're not going to have a problem with the burglaries, I would like to do everything except, so perhaps the Menendez jury should have a longer lunch.
All right, we'll have the Eric Menendez jury come back at 1:45 or 1:30, and the Lyle Menendez jury come back at 2 o'clock. And we'll excuse them at this time, and then I'll hear a brief further argument here regarding this evidence. Let's get them out and excuse them. No, this one is, we'll change. This one is 1:30. The other one is 2 o'clock. Give us a little time.
Sorry, which one is two?
1:30 here, 2 o'clock. We have the Eric Menendez jury here? Yes. Okay, 1:30. Okay. Okay, as soon as the jurors have left, we'll continue our discussion here.
I'm gonna be keeping